I've had the benefit of the exhaustive and erudite judgment of Chief Justice Chandrachud, which enumerates the prevalence of these relationships in history, the constitutional recognition of the rights to form union, in other words, what I categorize as civil unions, and the necessity of laying down guidelines to protect the non-heterosexual unions. In a way, this is a step forward from the decriminalization of private consensual sexual activities. However, the subject matter itself persuades me to pen down a few words while broadly agreeing with my brother's judgment. I've dealt with the historical prevalence of non-heterosexual unions. Uh, I've said that it is no longer res integra, that the duty of a constitutional court is to uphold the rights enshrined in the Constitution and not to be swayed by a majoritarian tendency or popular perceptions. This court has always been guided by constitutional morality and not by social morality. Uh, Pluralistic social fabrics has been an integral part of the Indian culture. I have referred to some observations from the Rig Veda and the Somdas Satya Sarigra. And then I've said the significant aspect is that the same-sex union were recognized in antiquity not simply as unions that facilitate sexual activity, but as relationships that foster love, emotional support, and mutual care. I've referred to some traditions in the Sufi traditions. Then I've said the marriage as an institution developed historically and served various social functions. It was only later in its long history that it came to be legally recognized and codified. However, these laws regulated only one type of social historical union, that is the heterosexual union. Uh, it would thus be misconceived to claim that non-heterosexual unions are only a facet of modern social milieu. The objective of penning down this section is to provide perspective on the existence of non-heterosexual unions despite continued effort towards their erasure by heteronormity of majority. Um, the non-heterosexual unions are entitled to protection under a constitutional scheme. I have referred to the necessity of recognizing what I've categorized as civil unions. The judgment of the Chief Justice notes the right to form union is a feature of Article 19 and 21. Therefore, the principle of equality enumerated under Article 14 and 50 demand this right to be available to all regardless of sexual orientation and gender. Having recognized this right, this court has taken on board the statement of the learned Solicitor General to constitute a committee to set out the scope of the benefits available to such union. I agree with the Honorable Chief Justice. I have referred to the Special Marriage Act and discussed the statement, object, and reason therefore. From the above, the SMA postulates a special form of marriage available to any person in India, irrespective of faith. Therefore, SMA provides a secular framework for solemnization and registration of marriage. It is here that I respectfully disagree with my brother Justice Bhatt that the sole intention of SMA was to enable marriage of heterosexual couples exclusively. To my mind, the stated objective of SMA was not to regulate marriages on the basis of sexual orientation. This cannot be so, as it would amount to conflating the differentia with the objective of the statutes. Although substantive provisions of SMA confer benefits only on heterosexual relationships, this does not automatically reflect the objective of the statutes. I've said if the intent of the SMA was to facilitate interfaith marriages, then there would be no rational nexus with the classification it makes of excluding not heterosexual relationships. Uh, then I've referred to the regulation of only heterosexual marriages would not be legitimate state objective, more so in cases where ex officio protected categories under Article 15(1) of the Constitution. However, I recognize, therefore, I have said that if this was so, the SMA would be violative of Article 14. However, I recognize that there are multifarious interpretative difficulties in reading the SMA to include marriage between non-heterosexual relationships. These have been enumerated in a significant detail in the opinions of both the Honorable Chief Justice and Justice Bhatt. I also agree that the entitlements devolving from marriage are spread across the proverbial spider web of legislations and regulations. As rightly pointed out by the learned Solicitor General, tinkering with the scope of marriage under SMA Act can have a cascading effect across these disparate laws. Um, um, in fact, the presence of this web of statutes show that discrimination under SMA is but one example of a larger, more deeper form of social discrimination against non-heterosexual people that is pervasive and structural in nature. Ordinarily, such an intensive form of discrimination should require keener and more intensive judicial scrutiny, but then that's the statute. Then I say non-heterosexual unions and heterosexual unions marriages ought to be considered as two sides of the same coin, both in terms of recognition and consequential benefits. The only deficiency at present is the absence of a suitable regulatory framework such for such unions. I refer to Navtej's view. I believe this movement presents an opportunity of reckoning with this historical injustice and casts a collective duty upon all constitutional institutions to take affirmative steps to remedy the discrimination. The next step in due course would be to create an edifice of governance that would give meaningful realization to the rights to enter into the union, whether termed as marriage or as unions. Then I've referred to the interpreting statutes using constitutional principles. As noted above, the benefits pertaining to marriage are spread across several incidental legislation and regulations. These statutes presently do not explicitly extend to civil unions. However, now that we have recognized the right to enter into civil union, such statutes must be read in a manner to give effect to this right, together with the principles of equality and non-discrimination under Article 14 and 15. In other words, statutory interpretations must be in consonance with constitutional principles that are enumerated by this court. Needless to say, this should not detract from the committee's task of ironing out the nitty-gritties of the entitlement of civil union. This exercise is necessary to foster a greater coherence within the legal system as a whole, both intercede the statutes and between statutes and the Constitution. I refer to some views from how the German courts and the South African courts have dealt with these issues. Then I've referred to the interpretation on issue of public policy. I've said this technique of reading constitutional values should be used harmoniously with other canons of statutory interpretation. I've gone on to the need for anti-discrimination law. I wholeheartedly in agreement with the opinion of Honorable Chief Justice that there is need for separate anti-discrimination law, which inter alia prohibits discrimination on the basis of sexual presentation. Presently, there are several laws that have anti-discrimination aspects. However, they are fragmented and may fail to capture the multitudinous forms of discrimination. Another compelling reason for a law that places a horizontal duty of anti-discrimination is provided by the spirit of Article 15, which prohibits discrimination both by the state and private actors. My suggestions for anti-discrimination law are as follows. First, such law should recognize discrimination in an intersectional manner. This is to say, in assessing any instance of discrimination, the court cannot confine itself to a singular form of discrimination. Instead, discrimination must be looked at as a confluence of factors, as identities and individual instances of oppression that intersect and create a distinct form of disadvantage. Discrimination laws can only be effective if they address the types of inequalities that have developed in a given society. Refer to the equal rights to equal love. The principle of equality mandates the non-heterosexual union are not excluded from the mainstream of socio-political framework. However, the next step would be to examine the framework itself. I believe the recognition of non-heterosexual union can challenge culturally ordained gender roles, even in heterosexual relationships. I've given some examples of it. Need not read it here. You can see it. In a non-heterosexual union, duties, obligations are primarily dictated by cultural ordained gender norms. Legal recognition aids social acceptance, which in turn increases the queer participation in public space. Through the medium of legal recognition, queer persons will have a greater opportunity to be seen and heard in ways not previously possible. Queer expression will help facilitate an expansive social dialogue, cutting across communities and generations. This dialogue will help us reimagine our relationships in a manner that emphasizes the values such as mutual respect, companionship, and empathy. Conclusion. Is this end where we have arrived? The answer must be an emphatic no. Legal recognition of non-heterosexual unions represents a step towards the marriage equality. At the same time, marriage is not an end itself. Our Constitution contemplates a holistic understanding of equality, which applies to all spheres of life. The practice of equality necessitates acceptance and protection of individual choices. The capacity of non-heterosexual couples for love, commitment, and responsibility is no less worthy of regard than the heterosexual couples. Let us preserve this autonomy so long as it does not infringe on the rights of the others. After all, it is my life in the song by Bon Jovi.
Having had the benefit of reading the draft and the revised opinions circulated by the learned Chief Justice, we find it necessary to pen our reasoning and conclusions in this separate judgment. The learned Chief Justice has recorded in detail the submissions by counsel and claims made. They therefore do not require iteration. Similarly, the sections addressing the Union government's preliminary objections, that is the discussion on the court's authority to hear the case and that queerness is a natural phenomenon that is neither urban nor elite, are parts we have no hesitation in agreeing with. However, we do not agree with the conclusions arrived by the learned Chief Justice and the directions issued. We do not agree with certain premises and conclusions that he has recorded. They are: one, that there exists no fundamental. We do agree with the premises and conclusions that he has recorded. They are that there exists no fundamental right to marry under the Constitution, that the Special Marriage Act is neither unconstitutional nor can it be interpreted in such a manner as to enable marriage between queer persons, and that transgender persons in heterosexual relationships have the right to solemnize marriage under the existing legal frameworks. We have briefly highlighted our main points of agreement and reasoned in more detail those aspects with which respectfully we cannot persuade ourselves to concur. We had the benefit of perusing the concurring opinion of Justice Narasimha. We endorse those observations and conclusions fully. The reasoning and conclusions shall be read as supplementing that of the present judgment. For long periods in societies, many societies, the choice of a matrimonial was not free. It was bound by social constraints. Much of the time, marriage was seen as an institution meant for procreation and sexual union of spouses. In most societies, marriage had cast roles for the spouse. They were fairly inflexible, with men controlling most decisions and women placed in a subordinate position with little or no voice, and for the longest time, no legal authority, autonomy, or agency. For millennia, custom, tradition, and law subordinated wives to husbands. Notions of